Hey, we have everyone before us in the Manatee County Board case, pardon me, and Christensen, Attorney Valenti. It's my understanding you were here on behalf of the appellant. Did you wish to reserve time?
Yes, sir. I'd like to reserve 5 minutes.
Okay. I will let you know when you get here, and I will speak louder than I did the first case because apparently you didn't come through very well. So I'm not trying to scream or yell. I just want to make sure that you hear me. So if it comes in too loud, let me know. I've already adjusted my microphone today because it seemed like I was shouting at everybody and everybody was shouting at me. I can understand the latter, not so much the former. I know why people yell at me, but so if it comes in, it's not personal. It's just, I want to communicate.
Understood.
Thank you, sir. And with that, we are ready to begin.
May it please the court. My name is Jim Valenti. I represent the Manatee County School Board, both below at trial and now here. First, would the panel like a brief recitation of the facts, or is that not necessary?
I think the panel is comfortable with the comprehension of the interesting facts on this case.
All right, sir. So I'll begin with the points that we made in our brief. The first one being that the trial court should have granted our motion for judgment on the pleadings pre-trial. We raised that again post-trial in what was first time I'd ever filed a motion for arrest of judgment. I had no idea what that meant, but apparently that was the proper vehicle to get that back before the court. And we believe that the judgment on the pleading should have been granted and the case should never have gone to trial. And the reason for that is because in paragraph 14 of the second amended complaint, which was what we were traveling under by the time we got to trial, the allegations of the complaint was that the Manatee County School Board, through its nursing administration, advised the students, warned them of possibility of criminal activity, and recommended that they walk in groups to and from parking lot to the nursing home. And then in paragraph 17, when they're describing what they say were the breaches of our duty of care, they list a lot of things, but none of them is the sufficiency of the warning.
If I may, Mr. Valenti, wouldn't you agree? I mean, there was no dispute whatsoever that the plaintiff was warned, and I think that's in the record. But wouldn't you agree with me with respect to your motion, basically for directed verdict, as to the issue of adequacy of the warning? There's case law, the City of St. Peter's versus Collin, that this is a classic jury issue regarding as to the degree, whether or not properly warned, it's whatever the term, quote, properly warned, that is up to the jury to make the determination whether or not. So if it's a jury question and if it's a factual question, you're trying to take the position that should be, as a matter of law, the fact that the plaintiff was warned, or just say that the appellee was warned, the end of subject. But isn't that a classic jury issue?
No, ma'am, not in this case, because first of all, that was never pled, that the warning was not adequate. This jury issue was never pled. And second, the Felix case, which is cited in our brief from the Florida Supreme Court, 1989, that case says that a breach cannot be the proximal cause of injury if the person receiving the warning understands the warning. She testified in trial that she knew from the warning that it was a possibility of criminal conduct. She knew everything that we knew. So I'm not sure how the jury could have possibly decided that the warning was inadequate when she admitted that she got the warning and she understood the warning. And I think they pled that. And then I think in the actual trial, she admitted that she knew the area could be dangerous. This is a 45-year-old nursing student at the time who's in an off-site parking lot not owned by the school board and gets assaulted by a third party, not an employee of the school board. The liability for the school board in a situation like this, I couldn't find a case that's even come close to the facts of this, where liability was allowed to be imposed on a government entity. Even the case cited by
Mr. Valenti,
yes, ma'am. Yeah.
maybe we're talking about two different things. Yes, she was warned, but isn't the issue the adequacy of the warning? Because wasn't there presented at trial? She said, oh, I was told, but then there was no follow-up. There was no emails. There was no, when we're talking about the adequacy of the warning, as opposed to simply, oh, be careful, this area is not very safe. Doesn't that play in?
Not when she testified that she knew that criminal activity was a possibility and that she understood the warning.
Counsel, isn't the purpose of
Valenti, did you have a record site for that testimony, please?
Excuse me, please?
Go ahead, Judge Allwright.
I'm sorry. Do you have a record site for that testimony? Because my recollection of her testimony, and I may be missing what you said, was she said, yeah, we were told to walk together, but we're always told that. This is like my fourth or fifth clinical. They always tell us to walk in together. I don't recall her testifying that she was either warned of potential criminal activity in the area or that she knew of it. So if she's testified in that regard, as you say, could I have a record site for that if you have one handy?
Yes, ma'am. Can I get back to you? I've got my associate, Sam Hensel, in the room, and she's looking for the actual site, and I don't want to hold us up for undue amount
Sure.
while we look for that, but I'll get what she actually said in trial.
Counsel, here's my concern. It may not have been, you may be in a situation that was never presented to the court for ruling, but the case law talks about you either have a duty to properly warn, or to take steps to avoid the danger. When the school board made the decision to approve the medical facility Evocare spot, that's protected by sovereign immunity. But how do you tell someone, here it is, be careful when you walk together at 5:30 in the morning. That way, if someone has an automatic weapon, they can take you all out. It's like, let me use an exaggeration to make a point. Look, you have to attend this orientation and you have to walk across the lava field to do it, but be careful, it's hot. That's all you have to do. Is that all the school board has to do? They can approve a situation with violence and then do nothing to avoid it or give the student a chance to avoid the potential harm.
Yes, sir. I believe, and the way you make it sound, it's ridiculous, but I think that's what Florida law is. That
Well, what's the purpose of the conjunction or when it says the case law is to take steps or to proper warn? Usually a warning says, be careful, there's a curve in the road or there's a hole in the road, you go somewhere else. You avoid the harm. Here, you're told there's a harm, and in order to avoid the harm, you should travel together. Not, here's how you avert the harm. We're going to have a person come up on an electric vehicle and pick you up. We're going to provide a security guard there, where Advocare is. It's like you're left to your own devices. I hope you make it safely. And that's how it comes across when I read this record about the duty to warn. It was like, we have done our bit, and now we have absolution.
Well, Your Honor, remember, we weren't allowed to present any testimony as to the adequacy of the warning. The fact,
Is there any proper order that I could look at to see what would have come in had the judge let you?
well, I can have my associate look, and I have,
That's okay. I can do that. I'll go ahead. I'll look. If you find
All
it,
right.
that's great. If not, I promise to look too.
okay, all right. Well, here was the cross-examination on the other point. Good morning, Ms. Christensen. Good morning. You testified on direct that you didn't get any other instruction about this church parking lot other than what you received at other facilities. Is that what I understood you to say? Yes. All right. But in fact, ma'am, didn't you Didn't Miss Parise, the program director, tell you to walk over in groups because it was not the best of neighborhoods? Yes. And that's all we knew. I mean, that's all that the administration knew. And this was testimony that came out in the record, was that some of the neighborhoods had some of the neighbors had bars on the windows, that it smelled like marijuana sometimes, and that there were dogs chained up. That's it. We weren't allowed to admit testimony that there had been no incidents for years there in the parking lot. And Judge Casanueva, to answer your question a little bit better, remember the legislature, you know, I mean, if anything, I thought what they could be liable for was picking the spot where they parked, or moving the clinical to somewhere else. But the law is that they're immune for that decision from putting in that, and the judge was correct on that. That's what he ruled.
I understand that. That's why
And
I was asking
then
on the other part.
And then on Dutco, the case that's being relied on so heavily by the other side, it said, even if you're sovereign immune from the decision, and that was a 12-year-old middle school student in a very dangerous roadway. That was the facts of the Dutco case. And they said you could still create a dangerous condition if you've had complaints, if there's been other incidences there. That now creates a duty for you to do one of two things: warn or whatever. None of the whatever was done, but the first part of the or was done. We gave them every bit of information that we had. And
So
I'm not
see anything in the record that said a police officer testified this was a high crime zone or anything like that.
No, sir. That would have been their job on a premises
That's what I
law.
said. I didn't see anything in the record, you know. Anyway,
Right.
so the categorization of this neighborhood is one that is a matter of someone's conclusion, and the facts are different. And that's what I'm trying to separate by using a very pointed exclamation point, you know, of a high. What is the fact? What is the conclusion? And I want to make sure I didn't miss any of them. And I think you've addressed it. I appreciate it.
Yes, sir. Yes, sir. Okay. So, I mean, we've talked about a lot of the stuff as we go on, but in the
Just so
Dutco,
you know, you're at 12.
all right, sir. And in the Dutco case, there was evidence that they failed to give an adequate warning, or any warning, actually, in that case, after the occurrence of multiple events and after the receipt of multiple complaints about how dangerous this was. I mean, I think the school board may have been better off just not saying anything. But these nursing administrators felt like, because there were some bars on the windows and dogs chained up, that, hey, when you get there, stay in your cars. Wait till everybody gets there, unlock your doors, and all walk in together. I mean, I think it's under the, you know, maybe the no good deed goes unpunished. And I think maybe what the jury was thinking, well, why were you even there if it was a dangerous neighborhood? But that's what's protected under sovereign immunity. So I think that we've handled the directed verdict part. The Felix case, again, says that a warning cannot be the cause of a plaintiff's damage if they understand the warning. And she understood it.
And Mr. Valenti, if I may, let me go
Yes,
back to Judge Rostin Newcomb's thing, because you've indicated that she was aware of that there was criminal activity, and I think you used the word criminal activity in that neighborhood. And then Judge Rostin Newcomb asked you for a record citation, and what you've basically read to us in the cross-examination, that she admitted it was, quote, not a good neighborhood, close
Yes,
quote. Not a good neighborhood, as opposed to, if I may.
Yes, ma'am.
And so I see the ultimate issue, and we talked about that, is the adequacy of the warning. So even though she was aware it was not a good neighborhood, is that a jury question for the adequacy of the warning?
Well, it is, Your Honor. I think and this would have been a better answer to her question, would have been, we didn't know it was a dangerous neighborhood other than the facts as were stated. And she knew that. Everything we knew, she knew. There was no evidence put on by the plaintiff that there had been other incidents, not only in that parking lot, but in the neighborhood. And certainly there was no evidence that the school board knew that. That is different than any other case that has held a school board liable for failing to warn after they have created a condition, is because they got information that they didn't convey. Even the information they did convey was just a conclusion based on, I mean, she wasn't hurt by a dog. She wasn't hurt by marijuana. She was hurt because it didn't appear to be the best of neighborhoods. That's exactly what she understood. And so we think, Judge, that whatever duty, if we had a duty in this case, that we discharged it. I don't think we even had a duty to warn because there were not any prior complaints or incidents. That's what Dutco required. And Dutco is the furthest out.
I need to let you know you hit 15.
All right,
There we go.
sir.
2 seconds.
Okay, so I'm going to take up
I'll give
maybe.
you, you're at 15 and a half. I'll give you an extra minute that I'll also give to opposing counsel.
All right, sir. I think the jury instruction was erroneous because it assumed that we created the dangerous condition. And in every other case where that's been decided, there was evidence taken on whether we created the condition. Again, under Dutco and every other case, there had to be prior complaints, prior incidences. We weren't allowed to say, and what we told the judge was that what they would have said if he would have let it was, we don't know of any incidences that have happened before. And that was evidence that should have gone. If adequacy of the warning is at issue, then the evidence of what we knew before giving a warning should have, if it's a jury question, the jury should hear the facts on that. And finally, Advocare, who was one time a party to the case, who settled out, we couldn't put Advocare on the verdict form when everything that could have caused liability for us in this case was true of Advocare. But they couldn't be put on the verdict form. They didn't warn anybody. They didn't take any steps. And they're the ones that told us to park there. So I think, and that's all for now. I'll save the rest of the time for rebuttal, Judge.
Thank you.
Good morning. Good morning, Your Honors.
Before
May I
you
please-
start, Attorney Silverman, I will let you know I've completed my mathematical computations despite being a liberal arts major. And you have 22 minutes.
I appreciate it. Thank you very much. It's a pleasure to be here before you this morning. I am Susan Silverman, and I am representing the appellee, plaintiff below, Katrina Christensen. And I'd like to start out by just adding to Judge Kuzum's comments about the adequacy of the warning as a jury question, and to specify why it was a jury question and the directed verdict was properly denied. And also that the warning that was given, other than that this was a bad neighborhood, there was nothing else given. And basically the warning, remember, first of all, the school board admitted and stipulated to the fact that the parking lot was dangerous. And the disputed issue of fact was whether the warning was proper in light of the danger. there was one warning given to the students. And that was to park in the church parking lot about a block and a half away from the facility, stay in your locked car or drive around until the other students arrived and walk in together. Notably, the warning was given at a one-time orientation session prior to the clinicals beginning. And no matter where the clinicals were being held, the instruction was the same. There were no written instructions, no written warnings, no emails, no texts, no reminders, not renewed after the initial orientation. So Riverfront,
Ms. Silverman?
yes.
So is your position not that the substance of the warning was necessarily inadequate, but maybe the failure to more emphatically convey it was what was inadequate?
I think the substance was wrong as well, and I will respond by saying that the fact that it was a bad neighborhood was the substance of it, other than just parking your car and walking together. It's dangerous. What Mr. Valenti was referring to about pit bulls and marijuana, that was never the substance of the warning. That was never warned about. It was, this was only the second time that the plaintiff was at this facility, but she had done
Relatively early in the session, correct?
correct. And she had done other clinicals, and there was really not a different warning for each. And all the other clinicals, they all try to walk in together as well. So she's already somewhat removed in time from the one warning. But then Ms. Baris, the person in charge of running the LPN program at MTI at the time, she testified she knew that there were always people on their porch at 5:30 in the morning. But Ms. Christensen didn't know that because the warning didn't include that. Ms. Baris said she knew everybody.
So we don't know who she was attacked by, right? We don't know if she was attacked by someone from the neighborhood, do we? And
Know
that
anything
just was
about the investigation. There was never really much of an investigation, so that issue was never resolved. We don't know, but there were factors within MTI's knowledge that were not conveyed, and she was not aware of those factors. And because of that, when she pulled in that morning on February 23rd, 2013, she was not really worried. She wasn't afraid. She testified she didn't feel unsafe. And because of, you know, the inadequate warning, she wasn't on high alert. And, you know, it was because of the inadequacy of the warning. Now, the school board had argued in its brief that the jury could not have found Ms. Christensen comparatively negligent if the warning wasn't proper. And that argument really doesn't make sense to me, but the way I see it, based on the evidence, they could have clearly found that without being confused, because I'm certainly not suggesting she was negligent, but the jury found that she was, and it reasonably could have found that even if it was a bad warning, if she didn't follow it completely by not keeping the doors locked, she could have been found to have contributed to the occurrence. And the jury did come back with a question for her about how long she had owned her car, because the car, when it was shut off, had automatically unlocked. And she responded to that question. Well, maybe it was 6 months, but she wasn't really sure. But certainly the jury verdict was consistent with the evidence and with what the testimony was and what the jury question was. So Clearly, there was more than enough evidence to create a jury question as to whether the warning was proper. And there's no basis to reverse the denial of the motion for directed verdict. I want to address the Dutko case because yes, we did rely on it, and yes, Mr. Valenti attempted to distinguish it by saying that, well, they weren't allowed to present evidence of prior complaints. And in Dutko, there were prior complaints and near misses at this particular bus stop. But Dutko goes further than that, as do other cases. And the evidence of prior similar incidents, that the satisfying of the creation of the dangerous condition argument is not limited to that. There could be other evidence to support that the dangerous condition was created by, for example, in Bailey Drainage District versus Starr, the governmental entity that maintained an intersection right-of-way that obstructed the vision of motorists had a duty to warn of the danger, even though they didn't plant the greenery. So this whole idea of the fact that there were no prior complaints or evidence of no prior complaints wasn't allowed doesn't really fully answer the question. And as far as the issue about the jury instruction, we know that the jury instruction came directly from City of St. Petersburg versus Colum, a controlling Florida Supreme Court case on the issue of a duty to warn when a governmental entity is immune from planning level decisions, but not from operational level decisions. We know that the jury instruction directly quoted from that. We know that Mr. Valenti argued that the term once a dangerous condition is created should not have been used, that it should have been if a dangerous creation. But the court had already found, because it was a planning level decision, that the school board couldn't be liable for it. And Ms. Christensen couldn't argue about that. They knew that the parking lot was dangerous. It stipulated to that fact. And the jury was properly instructed. In deciding the propriety of an instruction, the court just looks to whether it accurately stated the applicable law, the facts supported giving the instruction, and the instruction was necessary to allow the jury to properly resolve all the issues in the case. The decision to give an instruction can't be reversed unless it resulted in a miscarriage of justice or it was reasonably calculated to confuse or mislead the jury. And again, the idea that the jury found Ms. Christensen comparatively negligent, the argument that showed that the jury was confused, I already addressed that briefly, but I just want to add that at the charge conference, the school board asked for an instruction on comparative negligence. They had raised it as an affirmative defense. And when the judge asked the school board, well, what would make Ms. Christensen comparatively negligent? It responded by saying, well, she should have stayed in the car with the door locked. So it can't now complain that the jury was misled or confused when it found her comparatively negligent. And finally, with regard to the verdict form, the argument that Advocare should have appeared as a Fabry defendant. It could not have been on the verdict form properly because the school board was already benefiting from being immune from liability for choosing the parking lot. Fabry permits a jury to apportion fault between parties and non-parties. Fault can't be apportioned if the court has already ruled that the defendant is not liable for any fault for the choice of the parking.
Ms. Silverman, I want to sort of dig into that because my understanding of sovereign immunity doesn't mean there has been no wrongdoing on the part of the government entity. It's just that the government entity is immune from it, can't be held liable, or, you know, there can't be judgment entered against them on that. But it's a separate question as to what their actions actually were, right? I know I'm not articulating that very well, but hopefully you get the idea of what I'm saying. I mean, the government entity can say, we were negligent all day long, but you can't sue us for it. And so aren't they two separate questions?
Well, not in front of the jury. I mean, the jury was not allowed to consider any evidence of the choosing of either Riverfront as a facility for the nurses or the choosing of the parking lot.
But didn't the school board say, we're fine with that coming in if we get an instruction that we can't be held liable for any of it?
Well, I think what happened was there were several discussions about it. There was a discussion pre-trial, and then there was a discussion at the charge conference. And what the judge was ruling was that, well, if I allow the sovereign immunity for the plan, if I find this is a planning level decision and I allow the sovereign immunity defense on that, then certain evidence is going to be excluded on both sides. And
But with sovereign immunity, the immunity attaches to the sovereign, not to the decision itself. And so why couldn't the school board bring in evidence that we didn't make this decision alone? You can't hold us responsible for it, but these other people knew what was going on, and you should consider their role in it.
well, I think then what happens is then it becomes less of a planning level decision and more of an operational decision. And then
Why does it change the nature of the decision? If you could explain that to me, because that's something I don't understand. Do planning level decisions, is there a requirement they must be exclusively made without input from external sources? Because I don't understand why it changes the nature of the decision made.
sure I understand the question. I'm not
Well,
sure.
you said then it becomes, then you said, well, then it becomes more of an operational level decision. And what I don't understand is why it changes the nature of the decision being made.
Well, I don't think it changes the nature of the decision being made, but what it does change is the opening of the door of allowing evidence of different theories of liability and allowing evidence in, even though the court had already decided, and it relied on actually the case of State Department of Health and Rehabilitation Services versus TR, where it said that it was reversible error for the jury to be allowed to hear and consider matters for which recovery was completely barred by the doctrine of sovereign immunity. And I think that that's the avenue that the court was taking, and it was correct.
And I'm curious, Ms. Silverman, the fact of this case, let's just follow up to what Judge Rostin Newcomb indicated of the appellant wanting to have this entity placed on the verdict form. That's if there was no evidence that the school board kept on continuing. I mean, this is an ongoing thing. It's not a one-time thing where, okay, park on that parking lot just this one time. This has been, it's part of the clinical. She had to go there over and over. So that was continuance. The fact that it is the creation of a danger, it kept on continuing. They still allowed. So the school board, the school board continued that. So if they say, oh, it's not our fault, somebody else made that decision. Well, didn't they ratify the decision constantly by saying, it's not a one-time thing. This, it's an ongoing process. Does that weigh in to the mix?
I believe it does. And I think when it does, then after the initial selection, there was a contribution to the creation of the risk of injury, the danger. And that gives rise to the operational duty to warn.
And that's what and I'm trying to think it through that, okay, so the Fabre is like, okay, somebody else made this decision, they should be part of it in order to weigh, in order to have at least a jury to consider apportionment of fault. But in this case, given the facts that the school board kept on continuing, I mean, this quote unquote creation of danger was recreated every single time. So it's not a one-time thing like, oh, somebody else chose the spot. Well, they chose to continue it. So I guess it's selection and operation. So if they can't be liable for selection, but they're trying to split that with that. That's what I'm having.
Right, and I understand, and it's a difficult concept, but the way I understand it is because they allowed it to continue, that became, that gave rise to the operational duty to warn. That if there was that's how I can answer the question. And as far as the apportionment of fault, I just can't see how you can apportion fault when it's already been ruled that the school board can't be found liable for making that decision on the parking lot. And so it has zero. And then
And if I may, maybe I didn't articulate enough, and I guess just to respond to the fact about the Fabre issue, if there was no evidence that the school board allowed this to continue, then I think it's fair game. Fabre would be appropriate in this case, because then you're dealing more with, there's been, this action has been allowed to continue. So that becomes an issue for the jury to determine. It's an operational type of thing. And so I think what the judge here said, you can't have it both ways. You can't just say, oh, you're sovereignly immune, that regardless of what you've done, hey, even though we were negligent and selecting and whatever, we're not, but then later on allow that Fabre, because you're still, the school board still allowed that to continue on. That's how I understood the judge's ruling. Did I get it correct, or am I mistaken?
I agree. I think that was the judge's ruling, and ultimately he denied the request to have the Fabre defended because of his ruling on the issue of that they can't be liable for that decision of choosing the parking lot.
And the jury was told that. The jury basically, oh.
20. I just
Oh,
make sure she's
apologize.
at 20. You're at
Okay,
20.
Okay.
and Ms. Sylvan, the jury was instructed. I mean, they were instructed there'd be no liability for selection. They were given that instruction, correct?
They were given that instruction right before the
Okay.
follow-up instruction.
All
They
right.
were told they could not be responsible for selecting the riverfront facility, and they could not be responsible for selecting the parking lot.
All right. Thank you.
Thank you. Well, I would just submit that based upon the briefs and the arguments presented, that Ms. Christensen and I respectfully request that the court affirm final judgment in all respects. Thank you.
Thank you. Counsel, you have 5 minutes remaining.
All
You
right.
may proceed.
Sir, I'm going to just concentrate on two areas that I think have been an interest of the court. One is the Fabre. In the second amended complaint where Advocare was sued, they were sued for everything the school board was sued for, not just for picking the site, but for failing to protect her, what we would call in the Sovereign case, an operational duty, which if we were liable, the jury had to find that we violated the operational duty. The continuing that has been discussed was true of Advocare too. This was their facility. I mean, our choice, I guess, at some point was just to stop clinical duty in bad neighborhoods and just go where the rich people live for these nurses to train. Or I'm not sure what we should have done other than, but everything that we could have done, they could have done. I mean, Advocare could have said, well, no, we're going to let our employees park out there. They're used to it. They know everything. You students park, we'll give you space here. You didn't send a tram out there to bring them to. That's Advocare. Everything that they say we did, they said in their pleading that Advocare did. And they settled Advocare out. And they're out of there for their responsibility. But we weren't allowed to present evidence that the only reason we were there was because of Advocare, and that Advocare didn't do anything once we were there to mitigate the circumstance. If that's what the school board was negligent for, then Advocare was every bit as negligent for that. It was just as continuing with Advocare as it was for us. In fact, we'd been doing clinicals there for years for Advocare. And every time they told us we had to park out there. So that on the Fabre issue, I think that there can't be any question that when the plaintiff sues somebody for negligence for the same thing they sue the sovereign for, settle them out and then don't want them on the verdict form. Because it wasn't just the fact that Advocare chose the spot and we're sovereign immune for that. For one thing, they're not sovereign immune for that. And they were also sued for the other things we were sued for along the line. And yet they weren't on the verdict form. We weren't allowed to argue that they were responsible for it. And I think we should have been. And the other thing that I just wanted to comment on, and then I'll shut up. One of the elements of an operational duty is that we created the condition. So it only becomes an operational duty if we created the condition. We were not allowed to present evidence of all the things these other prior courts and cases relied on to say that we created the condition. Even in the case that counsel cited where there was a green, there was shrubbery blocking there was not even that here. So we should have been allowed to say why our warning was what it was. If the issue was the adequacy of the warning, even though she admits that she got that warning, and the testimony from our folks, and by the way, the testimony, and I'm sure counsel didn't do this on purpose, but it was specific to Riverfront. On page 439 of the transcript, our lady in charge of the program says, I clearly remember telling them at Riverfront, do this. And so it was specific to Riverfront. And I'm just not sure, other than to say, we can't do clinical here anymore. I'm not sure what, I mean, it's easy to look back and say some third-party criminal attacked this lady, but the way the facts developed and what the school board knew at the time, I don't know what else they could have done other than what they're sovereign immune for, which was having clinical there.
Thank you, counsel. We are just past 5. Finished
right.
right on.
Thank you.
Thank you both. Be safe. And we'll either see you live or in this method in the future. Take care now.
All right. Thank you.